Good morning, everyone. Welcome to the Public Service Commission of South Carolina, first hearing for 2021. Before we call this hearing to order, please join me in a brief moment of silence as we reflect on making it to 2021 and remembering those who we lost in 2020. All right, thank you very much. We're here in docket number 2020-125E. That is Dominion Energy of South Carolina's application for adjustment of rates and charges. This filing includes a request for an increase to retail electric rates. This hearing is now called to order. We will now have a roll call to see which commissioners are here with us. We will start with District 1, Commissioner Williams.
Commissioner Williams is present virtually.
Vice Chair Belzer.
Belzer's present in the hearing room.
Commissioner Caston. Commissioner Caston.
Commissioner Caston is present virtually, and I just lost video.
Okay. Commissioner Irvin. All right, Commissioner Irvin is present virtually. Commissioner Thomas.
Present virtually.
Commissioner Powers.
Present virtually.
Okay, and Chairman Williams is present in the hearing room. Now, ladies and gentlemen, I would like to tell you that the Public Service Commission of South Carolina is immune to COVID-19, but unfortunately that is not the case. We are socially distancing. A majority of our employees are working remotely. Some of our commissioners are joining us virtually, and some of our folks are out. So please bear with us as we try to hear this case in an efficient manner, but I'm going to ask for your patience up front. We may have technical difficulties here and there due to Murphy and his gremlins, but we're going to do our best to try to get through this hearing. If you have any questions about what we're doing or why we're doing, please don't hesitate to ask. We want to make sure that everyone gets a fair shake. All right, so we know that we're here in docket number 2020-125E, Dominion Energy of South Carolina's application for adjustment of rates and charges. At this time, I'm going to take appearances from the party, starting with the applicant.
Good morning, Mr. Chairman. My name is Chad Burgess, and I'm corporate counsel for Dominion Energy South Carolina. And with me today is Matthew Gissendanner. He is also in-house corporate counsel. We also have with us Michael Anselmo from the law firm of McGuire Woods, and we have the law firm of Willoughby and Hafer, who is represented by Tracy Green and Mitchell Willoughby. And we also have Belton Ziegler and Catherine Mansfield from the law firm of Womble, Bond, Dickinson. And we appreciate the opportunity, Mr. Chairman, to present the company's case to you. Thank you.
Thank you, sir. Now we will move to the interveners. CMC Steel, South Carolina. It's my understanding they have asked to be excused from this hearing, and they are excused. Sierra Club.
Good morning, Mr. Chairman, members of the commission. Robert Giles for the Sierra Club. With me is Dorothy Jaffe with the club's environmental law program, and Ms. Jaffe will be presenting our case.
Good morning to you all. Thank you for joining us. Department of Defense and all other executive agencies.
Good morning, Mr. Chairman and Commissioners. I am Emily Medlin. I'm representing the United States Department of Defense and all other federal executive agencies.
Thank you for joining us this morning, ma'am. The Department of Consumer Affairs.
Good morning, Mr. Chairman. Roger Hall. I'm an assistant consumer advocate with the department. In the room with me today is Carrie Gruby-Leibarker, who's our administrator and consumer advocate. And also on the screen there with us is Connor Parker, who is an assistant consumer advocate as well.
Thank you for joining us. Frank Knapp, Jr.
Good morning, Mr. Chairman. I'm Frank Knapp. I'm representing myself in this hearing.
Thank you for joining us, Mr. Knapp. Walmart Incorporated.
Good morning, Mr. Chairman. My name is Stephanie Eaton, and I will be representing Walmart in the hearing. Thank you.
AARP.
Good morning, Mr. Chairman. My name is John Kaufman, and I'm appearing on behalf of AARP together with local counsel Adam Prothero.
Thank you for joining us this morning. South Carolina Energy Users Committee.
Mr. Chairman, I'm Scott Elliott. I represent the South Carolina Energy Users Committee in this docket. Pleasure to be here.
Thank you for joining us this morning. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy.
Good morning, Mr. Chairman and members of the Commission. My name is Caitlin Nixon, representing the South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy. And with me here today is my colleague David Neal, who's been admitted pro hoc vice in this proceeding.
Thank you for joining us this morning. Office of Regulatory Staff.
Good morning, Mr. Chairman, members of the Commission. My name is Andrew Bateman. I'm representing the South Carolina Office of Regulatory Staff. With me today is Mr. Chris Huber and Mr. Alex Knowles. Thank you.
Okay. All right. So did I miss anyone? Hearing nothing from the parties, I assume that everyone is present and accounted for. We're going to move now to preliminary matters. The first matter I would like to discuss is the schedule. So today, as everyone knows, we were supposed to start at 10 o'clock. We're behind schedule due to technical issues. Starting tomorrow until we complete this matter, we will start at 9 a.m. and conclude at 6 p.m. Will that be a problem for anyone? Okay. Today, hearing no objection or concern, we will move forward with the 9 a.m. to 6 p.m. Daily schedule for the hearing. There are a few exceptions to that. One of those exceptions is today. Today we have public hearings starting at 1 p.m. To give our staff enough time to make sure we have fixed all of our technical difficulties. We're going to conclude today at 11:30 a.m. Okay. We also have public hearings on Thursday. Jocelyn, what time did the public hearing start on Thursday? 6 p.m. So we may conclude a little early on Thursday, since we're starting the public hearings at 6 p.m. Anyone have any questions? All right. Any other preliminary matters that need to be addressed at this time from the parties?
Mr. Chairman, this is... Oh.
Go ahead, Andrew.
Mr. Chairman, this is Andrew Bateman with the South Carolina Office of Regulatory Staff. I have two quick things. One, on December 30th, ORS filed a letter regarding the estimated time of cross-examination for company witnesses. In that letter, we let the Commission know that as of December 30th, we did not know the estimated time for cross for those witnesses. We are in a better position to state that now to the extent the Commission wants it believes it to be helpful, and I wanted to offer that to the Commission in the event they wanted that, Mr. Chairman.
Please offer it.
Sure. Now, Mr. Chairman, a couple caveats. These are estimates and subject to change. We understand some of these questions that we have for company witnesses may be asked prior to our cross-examining company witnesses. With those caveats, for company witness Blevins, ORS plans on spending about 15 minutes. For company witness Coffer, ORS plans on spending about 20 minutes. For company witness Elbert, ORS plans on spending about 15 minutes. For company witness Fetter, ORS plans on spending about 15 minutes. For company witness Noraki, ORS plans on spending about 15 minutes. And for company witnesses Whitley and Kassam, the same, about 15 minutes each. The second preliminary matter, Mr. Chairman, ORS would like to request the ability to give opening statements if the commission so desires.
Yes, opening statements are welcomed at the appropriate time.
Thank you, Mr. Chairman. Just let me know when the commission would like those, and ORS is ready to go.
Thank you, Attorney Bateman. So those are ORS's preliminary matters. Anything else from the other parties?
Yes, Mr. Chairman, this is Roger Hall with the Department of Consumer Affairs.
Yes, sir.
One brief matter. We had requested, along with, I believe, 2 or 3 other parties, protection for one of our witnesses from testifying on a particular date. I don't recall seeing a response to that, and just wanted to raise it now. It's not quite an issue for our witness yet because his conflict is January 13th. So if the commission's not inclined to rule on that matter yet, I understand. Just wanted to raise it at this time.
Okay. Thank you for raising that issue or bringing it up with us. Do you have that date available?
For our witness, it is witness David Dismukes, and he is has a conflict on January 13th. Which is next Wednesday.
So he can testify anytime before or after January 13th?
That's correct.
Okay. That request is granted.
Thank you.
Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy. We also had one witness who had a conflict for January the 8th, this Friday. His name is David Whiteley. If we have not made it to Mr. Whiteley by Friday, we would skip over him on Friday and pick him back up on Monday. And we would ask that he be allowed to be taken out of order that we've already presented to the commission by way of a letter last month.
So that's is it just Mr. Whiteley or is it also Mr. Parker?
No, sir, it's just Mr. Whiteley. Mr. Parker's conflict has been resolved.
Okay, that request is granted.
Thank you, Mr. Chairman.
Yes, sir.
Mr. Chairman, this is Emily Medlin. I have a request along the same lines. My witness, Dr. Zhu, has a conflict on January 12th and January 14th, and we would request protection from those dates for him.
Did you say the 12th and the 14th of January?
Yes, Commissioner.
Okay, that request is granted.
Thank you.
Mr. Chairman, this is John Kaufman on behalf of AARP. I also have an issue with our witness, Scott Rubin. He also has conflicts on the 12th and the 14th. So as others, we filed a letter and would wish to have him protected on those 2 dates.
All right, that request is granted.
Mr. Chairman, this is Michael Anselmo for Dominion Energy. I don't know if this is the appropriate time, but there are several pending motions that are to be addressed this morning, and I believe we can streamline the Commission's docket this morning by advising that some have been resolved. And if you'd like me to discuss that now, I'm happy to. If you need me to wait till later, I'm happy to do that as well.
Okay. Let's do this. Let's make sure that we get all the witnesses who need protection out of the way, and we'll get to those motions. Is that fair?
Yes, sir.
All
yes,
right.
sir.
Thank you very much. Is there any other party who has witnesses who need protection? All right, that was quick and easy. Let's go back to the motions.
Thank you, Mr. Chairman. This is Michael Anselmo again for Dominion Energy. There are several pending, or some pending motions for partial summary judgment addressing the company's proposed revisions to Section 5 of the General Terms and Conditions. The parties who have filed motions or responsive documents or supplemental testimony to that issue are the company, the Office of Regulatory Staff, the Department of Consumer Affairs, and the Department of Defense. The company at this time wishes to withdraw its proposed revisions to Section 5 of the General Terms and Conditions. We have spoken with the other parties and believe they will confirm they have no objection to the request for the company to withdraw those Section 5. Should the company elect in the future to pursue changes to Section 5 of its General Terms and Conditions, the company will open a new docket with the Commission and provide the requisite notices to the parties that it should do so. That would obviate the need for argument on the motions for partial summary judgment and the Department of Defense's joinder in one of those motions for partial summary judgment today, and also relieve the Commission from a need to rule on the issue in the final order. We do have other proposed revisions to the terms and conditions presented in this case. Those remain as filed with the Commission, and do not believe there's been any objection to those at this time.
Thank you, sir. Response?
Mr. Chairman, this is Andrew Bateman with ORS. ORS does not oppose the company's request to withdraw its proposed revisions to Section 5 of the General Terms and Conditions from this docket. Thank you.
Thank you.
Mr. Chairman, this is Emily Medlin for DOD, and the same, we agree with ORS. No opposition on our part.
Thank you.
And likewise, Mr. Chairman, the Department of Consumer Affairs does not object to the request to withdraw the revisions to Part 5.
Dominion Energy South Carolina's request to withdraw is accepted. Okay.
Thank you, Mr. Chairman.
Are there any other preliminary matters that we need to address?
Yes, Mr. Chairman. This is Michael Anselmo again for Dominion. We have a pending motion to strike certain testimony filed by the Department of Consumer Affairs in this matter, and would like to briefly present argument to the Commission on that matter. You have received briefing from the company as well as the Department of Consumer Affairs on this issue, but we would like the opportunity to address it with you now. We think it would be in the Commission's best interest to rule on the matter prior to the testimony being given from the expert that is the subject of the motion, Mr. Hempling.
Let me ask you this, Counsel. How long do you think, and I know you don't know how many questions you may field, but based on what you have to say, how long do you believe that oral arguments would last?
Mr. Chairman, I believe I can present my position rather succinctly in 2 to 3 minutes, then subject to any questions that the Commission may have thereafter.
All right, please proceed.
All right. Thank you. Like I said, the company is moving to strike certain portions of Scott Hempling's testimony as impermissible expert testimony. Expert testimony has limits in South Carolina. One of those limits is we do not permit an expert from providing his opinion on what the law is. how the finder of fact here, the commission, is to apply the law, or why that law should be applied in a certain way. But that's exactly what the department seeks to do with Mr. Hempling's testimony. He provides ample testimony on the presumption of prudence and gives advice on to the commission on how to apply it and why it should be applied, and actually how they should change settled South Carolina law on this issue. And how do we know he's doing that? Well, he admits it in testimony. Mr. Hempling admits his testimony is to, quote, explain the presumption, critique it, then offer the commission ideas for how to correct the presumption's infirmities, close quote. What's really problematic about that is quintessential legal advice that invades your providence as the commission to apply the law. It has no bearing on the factual evidence, and it's not needed for you to understand the factual evidence. What's even more troubling is he seeks to, in his words, correct the presumption's infirmities using law that is not South Carolina law. He goes to other jurisdictions that perhaps he prefers and tells the commission to apply it in a way that would destroy South Carolina's presumption of prudence. The South Carolina law is settled on this issue. A utility's expenses are presumed to be reasonable and incurred in good faith. So not the testimony that Mr. Hempling offers is irrelevant, but also gives legal framework that the commission can use to alter that principle, as I've said before. That is completely improper under South Carolina Supreme Court case law, as well as Rule 702 of our Rules of Evidence. Now, Mr. Hempling, in his response, did say he was linking his advice to the facts of the case in an attempt to escape this bar that has been imposed by our Supreme Court. But our Supreme Court has also rejected that testimony. In the Dawkins case that we cite extensively in our papers, that's precisely what Professor Freeman sought to do. He attempted to link the factual evidence in the case to the law as he advised the court to apply. And the Supreme Court said it was improper. And the reasoning was, quote, legal argument as to why the court should rule on an issue before the court is simply inadmissible. Again, because it has no bearing on the facts of the case. Now, it is not mere background that Mr. Hempling seeks to provide. He makes clear in his testimony and in the response that he's providing context, his words here, boundaries and principles for the commission, quote, to apply in rendering its decision. That is simply improper. It should be struck, as we've outlined in our motion, and violates Rule 702 and our Supreme Court precedent. Other arguments that I presented in the papers, we ask that the commission consider those, but I will be happy to answer any commission questions at this time.
Before we ask the commissioners if they have any questions, or take any questions from the commissioners, is there a response to the motion?
Yes, Mr. Commissioner. Roger Hall with the Department of Consumer Affairs. First, I'd like to address one thing. I believe there was I don't have it in front of me, a hearing officer directive or a directive from the commission on this matter that had said that oral arguments would be set in this matter, and I believe the commission had stated that they would rule on the matter in the final order. Certainly, if the commission changes that, but I just wanted to point that out at this time. I don't want to rehash everything that's been stated in our response to Dominion's motion, but they have misstated the case law. The case law clearly allows this testimony, but really the issue is a lot simpler, and it's a common sense issue. And much like Mr. Hempling's testimony, it's a matter of policy for the commission to consider. As the commission has noted, they sit as judges, and they are entitled to hear testimony and give that testimony whatever weight it deems appropriate during the course of the hearing. Courts have time and again found that judges have discretion to admit testimony, and there is no abuse to allow this testimony, particularly when there's no separate jury involved. The commission has also noted that it sits as a trier of fact akin to a jury, and that the role of the jury is to weigh evidence. If Dominion's motion is granted, you will not get to weigh evidence in this case, Mr. Hempling's testimony, as it will not be part of the record. I'm not sure why Dominion wants to deny the commission this entitlement, but they have suggested not to remove particular statements from Mr. Hempling's testimony, but rather a broad sweep of 17 pages of it. Again, regardless of their reasons, there is no South Carolina law or case precedent that prohibits the commission from accepting his testimony into the record. Contrary to what counsel has stated, Rule 702 actually supports the admission of his testimony, which provides that specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact at issue, then a qualified expert may testify in the form of an opinion. Mr. Hempling's testimony does enlist policies and principles that he has developed, studied, and implemented in his 35-year career and his numerous publications. As a couple examples of these common sense principles are prudence requires carefulness, precaution, attentiveness, and good judgment. He states a prudent utility has the lowest reasonable rates consistent with interests of the public and utilities. This specialized knowledge that he does provide context and background for the commission to understand the evidence, or lack thereof in this case, and will assist them in determining facts regarding Dominion's cost and prudence. Rule 704 also allows...
Excuse me, sir?
Yes.
I terribly hate to interrupt you, but we're having a little trouble hearing you. Could you speak up a little bit, please, sir?
Sure. Can you tell me kind of maybe where... Do I need to pick up somewhere, or...?
Well, no, we could hear you, but we couldn't get any closer to the speaker, so...
Okay. Yeah, let me move a little closer.
We want to hear you loud and clear.
Sure. Is this better?
That's a little better. Is there any way you could put that microphone closer to your...
Yeah, let me see what I can do.
It also helps our court reporter as well.
Sure. How about now?
That's a little bit better.
Okay. All right, I'll try to speak up. Just stop me if I start yelling at you. So anyway, another rule, South Carolina Rule of Evidence that does allow Mr. Hempling's testimony is 704. It clearly states that testimony in the form of an opinion is not objectionable because it embraces an ultimate issue to be decided by the trier of fact. Mr. Hempling's testimony is relevant to one of the most important issues in this case, whether Dominion's costs that it seeks to recover were prudently incurred. And again, his expertise will assist the commission in reviewing the evidence. The fact that Mr. Hempling cites law as support or policy does not make the testimony legal reasoning. It shows that his policies are legally accepted. This is no different from Dr. Vanderweide or another ROE witness citing cases like Hope and Bluefield. In regulatory policy making, in this context, law and policy often overlap. The South Carolina utility laws use broad phrases like just and reasonable and prudence. These give the commission the ability to implement policy decisions based on those laws. Mr. Hempling makes recommendations about policy. It is not a new methodology. It does not violate binding precedent. It does not create a wholesale rewrite as Dominion threatens. In fact, Mr. Hempling does cite to the leading Supreme Court case on the matter, Utility Services of South Carolina versus ORS, which states the presumption in a utility's favor clearly does not foreclose scrutiny and a challenge. In those circumstances, the burden remains on the utility to demonstrate the reasonableness of its costs. Mr. Hempling's testimony is simply that Dominion has not shown any evidence of prudence, and therefore, consistent with that case law, if the commission has a tenable basis for believing a cost is not prudent, it should raise it and require Dominion to meet its burden. Again, Mr. Hempling's recommendations are common sense. Here's just a couple that he includes. The commission should require real evidence of prudent performance, objective facts. The commission should require those facts on any issue for which the commission has reasonable skepticism about the utility's prudence. As I mentioned previously, this is no different than an ROE witness. An ROE witness states what he believes is a proper ROE and provides the methods they use to ascertain that number. Mr. Hempling does the exact same thing. His testimony pertains to how methods and tests of determining prudence should be applied. He doesn't reach a legal conclusion of whether or not Dominion's costs are prudent. He does, however, point out the simple fact that Dominion does not address prudency at all in their application or testimonies. So, in conclusion, again, I won't bother running through the case law. if you look at our response previously, we clearly showed that the Supreme Court distinguished Dawkins in a case called State versus Morris, where clearly an expert was allowed to address hypothetical questions and answer whether something was legal or not. So that issue, we believe, is clear. Again, in conclusion, the Commission has stated before it is entitled to hear testimony and give that testimony whatever weight it deems appropriate during the course of the hearing, and therefore we believe their motion should be denied.
Thank you, gentlemen, for your arguments. The Commission will rule on this matter in the final order. Are there any more preliminary matters that we need to take out before we start with opening statements?
Mr. Chairman, this is Andrew Bateman with ORS. Let me get my video. I inadvertently forgot to ask that the protest letters on DMS be put into the record as a composite hearing exhibit, Mr. Chairman. I believe as of a few moments ago, there were 87. I'd request that those protestant letters be put into the record as the next composite hearing exhibit.
The protest letters will be entered into the record as a composite exhibit, and that will be hearing exhibit 1.
Thank you, Mr. Chairman.
Oh, I'm sorry, hearing exhibit 7, not 1, 7.
Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy, and I certainly understand your ruling, and I would just like to place an objection on the record. The company doesn't have the opportunity to cross-examine any of those witnesses. There's been no foundation laid for those letters. So we just want to make sure that the record is clear that we do object to those letters of protest coming in because we do not have the ability to test the accuracy or the veracity of the statements that are included in those letters. Thank you, Mr. Chairman.
Thank you, Mr. Burgess. Your objection is noted for the record. Okay. Anything else?
Mr. Chairman, this is Stephanie Eaton for Walmart. I wanted to raise a potential issue as to testimony that might involve confidential exhibits. I have been in contact with Dominion's attorneys about potentially using a confidential exhibit. We are still trying to work that matter out, but I did want to bring that to your attention that we are trying to work that out without having to come back, but it is possible that throughout the course of this hearing, the Commission may have to address how, just procedurally, to allow parties who have received confidential information during the course of discovery to be able to use those to examine witnesses and just ask them questions about those. So I did want to raise that to the Commission's attention. Thank you.
Thank you for bringing that matter to our attention, ma'am. I appreciate you and Dominion and the other parties working on this issue. The Commission is working on it as well, and hopefully we will have it resolved when it's time to review those confidential exhibits.
Thank you.
No problem, ma'am. Any other preliminary matters? Hearing none, let's move to opening statements. Now, ORS was the only party to request, at least here on the record, request to make opening statements. Does any other party wish to make opening statements in addition to ORS?
Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy, and we would like to make an opening statement as well.
Okay. So, ORS, Dominion Energy, South Carolina.
This is Frank Knapp. I'd like to make an opening statement.
Frank Knapp.
Mr.
Chairman, this is the Commission with Chase and CCL. We would also like to make a brief opening statement.
Okay.
This is John Kaufman for AARP. We would also like an opening statement, very brief, just a couple of minutes.
Okay. Well, that's the majority of Other folks, well, not quite. Anyone else?
Mr. Chairman, this is Scott Elliott. I'd like to make a brief opening statement.
All right. Well, we're
And
just
this is
going to.
Dorothy Jaffe on behalf of Sierra Club. We'd also like to do an opening statement.
All right. Well, let's go ahead and get.
And for Consumer Affairs, Mr. Chairman.
And Walmart.
All right. So we're going to start from the top with the applicant. Please proceed with your opening statement.
Good morning, Mr. Chairman and members of the commission. I'm Chad Burgess, appearing on behalf of Dominion Energy South Carolina, and the company appreciates this opportunity to tell you about all the activities that it has been doing with respect to its electric operations since its last rate case in 2012, over 8 years ago. And as you hear from each of Dominion Energy's witnesses, please keep in mind that every activity done over the past 8 years has been done in such a manner so as to ensure that customers enjoy safe, reliable service while receiving the economic delivery of affordable energy. And let me begin by stating that Dominion Energy is fully aware of the times within which we all live. And we know that the pandemic has been hard on everyone. It's been tough mentally, it's been tough physically, and without a doubt, it's been tough financially. And like everyone, we would have preferred to have never known the word COVID-19 or be subjected to daily reports of positive COVID-19 cases and hospitalization usage rates. We wish we were not in a pandemic, but now that a vaccine is in the process of being distributed, we are hopeful that we're on the backside of this event. But even with a vaccine being distributed, the pandemic remains a worry among our customers, and this fact is not lost on us. We've heard the concerns that our customers have expressed during the public hearings, and Mr. Blevins, our president, is going to have a conversation with you about that when he takes the witness stand in a few moments. Even in a pandemic, Dominion Energy has a job to do to provide safe and reliable power to its customers, and we've done that. We've honored our obligations under the regulatory compact. Mr. Blevins and Mr. Kassam are going to discuss with you a measurement known as SAIDI, which stands for System Average Interruption Duration Index. And put simply, it's the standard that we use to measure our level of success of keeping the lights on. And it's not only good, it's great. Our customers know when they flip the switch in their home or at their place of business, the power is coming on, and if their power has been knocked out for any reason, it's coming back, and it's coming back quickly. But you don't get to great by not investing in and maintaining the system. And that's exactly what we've done over the past 8 years. And let me give you some numbers. Since 2012, we have invested $3.2 billion into our electric system. These investments have been required to ensure that the company continues to provide safe, reliable, and efficient service to its expanding customer base. This is accomplished by replacing aging equipment with reliable and resilient assets and meeting increasingly strict federal safety, reliability, and security standards. $3.2 billion is what we've spent, and it's indisputable that customers are enjoying the benefit of these assets. You can get in a car or truck today and ride all over the nearly 16,000 square miles of Dominion Energy Services territory and see the assets with your own eyes. They include 53,000 new or replacement distribution transformers, 3,100 new or replacement miles of distribution lines, 882 circuit miles of new transmission lines, and 29 new switchyards and substations. And since the close of the prior test period for calendar year 2011, Dominion Energy has also invested in upgrades, improvements, and additional environmental controls for its generation plants. These investments have been required to maintain the safety, reliability, and efficiency of these plants and to ensure their compliance with current environmental regulations. We've also invested in technology and equipment to better serve our customers and enhance system security. And we've added about 80,000 new electric customers, bringing our customer count to approximately 753,000. That's how many customer accounts depend upon us every single minute of every single day. And I say accounts, but the number of actual people that rely upon us every single minute of every single day is much higher. Now, I've told you that we've spent $3.2 billion, and you've got to turn that $3.2 billion into a rate for all customer classes. And by the way, for that $3.2 billion in investment, South Carolina law tells you that the starting position for your legal analysis is that those assets, those costs are presumed to be prudent. It's a rebuttable presumption, sure, but it's still a presumption that the costs are prudent from the beginning. And contrary to what any other party in this proceeding may tell you, this is black letter law in South Carolina. Now, I want to turn to one of the principal issues that must be decided in any rate-making determination proceeding, and that is the return to be allowed on common equity. And to start with, I want to make sure you understand that the company is not asking to be allowed the opportunity to earn any more on its assets than it already has been authorized to earn today. To be clear, Dominion Energy is not seeking an increase in its authorized rate of return. We're only asking that you hold it steady. Dominion Energy was awarded a return on equity of 10.25% in 2012, and it's entirely appropriate to allow Dominion Energy the opportunity to continue earning 10.25 today, as will be testified to by company witness Dr. Vanderweide. The issue, however, is that the company's current retail electric rates do not and will not generate an opportunity for the company to earn 10.25%. Instead, the company's actual return on equity is 5.9%, which is 42% lower than the authorized rate of return. An actual return of 5.9% is far too low to support the safe and reliable manner in which Dominion Energy operates its electric system, and which our customers have become accustomed to over the years and expect from us. Now, the cost of equity is market-based, and certain witnesses for other parties of records who will be presented in this case will tell you that 10.25% is too high. And they reach this conclusion because all of their analyses have a downward bias toward generating a depressed return on equity for the company. And what I mean by that is certain other parties have intentionally formulated their analysis in such a way so that it will derive an ROE that is much lower than that presented by Dominion Energy. And one of the ways they get to a depressed ROE is to rely upon a capital structure that does not reflect the company's actual capital structure. Simply put, they prefer to rely upon a hypothetical capital structure as an input in their ROE analysis, and this is wrong. Unlike the cost of equity, the cost of debt and preferred stock is contractual in nature, and it can be directly observed. Dominion Energy has presented to you in this case its actual capital structure. Now, I don't want this fact to get lost in this proceeding, but Commission Order 2018-804 required the company to rebalance its capital structure, and that order also told us to improve our credit metrics. Our actual capital structure of 53% equity and 47% debt does just that. There's nothing hypothetical about it. This is the true and correct capital structure of Dominion Energy from which an ROE should be derived, and it is in full compliance with the Commission order that I just referenced. Now, I want to turn your attention to another issue in this case, and that is the storm damage reserve that Dominion Energy has presented to you for approval. This is nothing new, as it was originally approved by the Commission in 1996. Dominion Energy simply wants to turn its storm damage rider back on. A storm damage rider is the simple act of funding a mechanism that will allow the company to repair its system after a major weather event while reducing the likelihood of having to return to the Commission for recovery of these costs. This is prudent planning. We all know that another hurricane is going to hit the company's service territory. It's not a matter of if, it's a matter of when. And the prudent thing to do is to be prepared for that event and fund a storm damage reserve, which is the appropriate mechanism to address the company's response to a natural disaster. In addition to funding a storm damage reserve, the company is proposing to establish a vegetation management accrual to provide a predictable basis for funding a multi-year vegetation management program. The effect would levelize vegetation management expenses over an average 5-year vegetation management cycle. This is important because vegetation management is a critical component of providing safe and reliable service to our customers. In fact, vegetation accounts for the highest number of outages on the company's distribution system, and the key to effective vegetation management is disciplined adherence to a regular cycle of work. The vegetation management accrual will serve this purpose. And lastly, I want to talk with you about savings. During 2019, we were able to achieve approximately $45 million in savings due to integration of systems and processes where economies of scale were possible. This was accomplished through labor synergies as well as non-labor synergies. These are real savings that customers are benefiting from as a result of the merger, and customers' costs are lower, and this cannot be ignored. In fact, in the commission order I cited earlier, 2018-804, that order clearly directed the company to file a rate case to ensure that the benefits of merger savings were realized by customers in 2021. At the end of the day, what does all this mean for the customer and for Dominion Energy if you grant the relief requested by the company? For our customers, it means they will continue to enjoy a safe and reliable electric system at an affordable rate, which for the typical residential customer is less than it was in January of 2013, net of new nuclear charges, which corresponds to less than 1% per year increase in rates since the rates were last adjusted. And to put that in perspective, the Consumer Price Index shows that producer prices have increased by approximately 14% since the close of the prior test year. And for Dominion Energy, it means that the company will have recovered its cost and will have been provided the opportunity to earn a reasonable rate of return on its assets. This, Mr. Chairman and members of the Commission, is equilibrium that the regulatory compact and regulation is designed to achieve. Thank you, Mr. Chairman and members of the Commission, for your attention to this most important issue for Dominion Energy and its customers. After you have heard all the evidence in this proceeding, I respectfully request that you grant the company the relief that it has requested in its application as amended by the testimony of the company's witnesses. Thank you.
Thank you so much. Sierra Club.
Thank you, Mr. Chairman and Commissioners. My name is Dorothy Jaffe, along with Robert Guild on behalf of the Sierra Club. Now, Sierra Club intervened in this case because we are concerned about the continued capital investments in Dominion's coal plants, Wateree, Williams, and Cope, without Dominion having conducted a retirement or economic analysis of those plants. Now, if these coal plants are already losing money and likely to continue to lose money into the future, then this commission and the ratepayers need to know that before it commits more ratepayer money to keeping these coal plants online, especially in the current economic climate. Now, this is something that the commission also seems to be concerned about based upon your recently issued final order on Dominion's 2020 IRP. And Sierra Club would like to take this opportunity to thank the commission for a very well thought out and thorough final order and for recognizing the importance of a retirement analysis, which coincidentally simplifies our ask in this case. Your final order requires a few things that can impact this case. First off, you require Dominion to conduct a retirement analysis prior to making any decisions to retrofit Williams and Wateree to comply with the effluent limitation guidelines. Second, your order stated that you will be opening a new docket to assess the reliability risks and costs of continued operation of these coal plants, as well as options to replace the coal plants with clean energy. Now, as Sierra Club expert Dr. Stanton will testify, Dominion is proposing to recover $411 million in capital expenses associated with these coal plants, which are only justified as long as it is prudent for Dominion to keep its coal units online rather than retiring them. Dominion has not yet performed an economic evaluation of its coal units and has not demonstrated that it is prudent to burden the ratepayers with the cost of continued investment in an operation of these units. Until that robust retirement analysis is conducted and the new docket assessing the reliability of the coal plants is concluded, this commission should require Dominion to maintain the status quo on all capital investments at the coal plants, not just the roughly $250 million in effluent limitation guideline investments. The two items mandated by this commission's final order in the IRP docket will provide valuable information on whether or not continuing to operate each of its existing coal-fired units is the least cost alternative as compared to other supply-side and demand-side resource options. And as Dr. Stanton's testimony will show, these very same coal plants are already losing money. The Sierra Club will ask that after you've heard and reviewed the testimony and the exhibits in this case, that you disallow the $411 million in past capital spending for the Watery, Williams, and Cope coal plants. We would also ask that you place a cap on future capital expenditures intended to prolong the lives of the Watery, Williams, and Cope coal units until the mandated retirement analysis and the new coal docket are completed, which would happen sometime before the 2022 IRP updates. We appreciate the opportunity to be here, and we look forward to participating over the next week. Thank you.
Thank you, ma'am. Department of Defense and other executive agencies.
Good morning, Mr. Chairman. We have no opening statement.
Thank you, ma'am. Department of Consumer Affairs.
Thank you, Mr. Chairman. Again, I'm Roger Hall, Assistant Consumer Advocate with the department, joined by Carrie Gruby-Leibarker. I don't think that was me. Sorry about that. Also with me are Carrie Gruby-Leibarker, the department's administrator, and Connor Parker, an Assistant Consumer Advocate. As you all know, in 2018, the legislature restored the department's authority to intervene in utility rate-making matters before the commission in order to advocate for the interests of consumers, and that's why we're here today. The department plans to present 3 witnesses. We briefly discussed Scott Hempling. He is an author, professor, and attorney who has spent over 35 years working in this field. He's worked in private practice, public interest organizations, and was the executive director of the National Regulatory Research Institute. His book, Regulating Public Utility Performance, The Law of Market Structure, Pricing, and Jurisdiction, was published by the American Bar Association in 2013. He's also written 2 other books and several dozen articles on utility regulation. He's currently an adjunct professor at the Georgetown University Law Center, where since 2011 he has taught public utility law and regulatory litigation. Mr. Hempling will present testimony on 2 primary issues. One, cost effectiveness and the presumption of prudence. In this area, Mr. Hempling recommends the Commission require evidence of prudent performance, not on every issue, but only for any issue for which the Commission has reasonable skepticism about Dominion's prudence. The other issue he addresses is Dominion's incentive compensation plans, where he recommends that Dominion base its incentive compensation...
Excuse me, sir? You're starting to fade out on us there again.
All right.
There you go.
Okay. His second area is Dominion's incentive compensation plan, where he recommends that Dominion base its incentive compensation on operational benefits for its customers rather than financial performance. Our second witness is Aaron Rothschild. He is president of Rothschild Financial Consulting and has provided financial analysis in the utility sector since 1996. He's prepared rate of return testimony since 2002, appearing in over 50 hearings in 11 states. His testimony focuses on the cost of capital and rate of return, which should be authorized for Dominion. He calculates a cost of equity between 8.19% and 9.07%, uses a cost of debt of 5.56%, and resulting in an overall rate of return between 7.33% and 7.76%. His recommendations will allow Dominion an opportunity to earn a return commensurate with returns on investments and other enterprises having corresponding risk, and will lead to just and reasonable rates for consumers, as required by Hope and Bluefield. Our third witness is Dr. David Dismukes. He's a consulting economist with Acadian Consulting Group. They are a research and consulting firm that, among other issues, specializes in the analysis of regulated and non-regulated energy industries. He is also a full professor, executive director, and director of policy analysis at the Center for Energy Studies at Louisiana State University, and serves as a senior research fellow at the Institute of Public Utilities at Michigan State University. He has provided testimony in nearly 200 utility-related matters. His testimony will focus on Dominion's proposed cost of service study and its proposed revenue distribution and rate design. And he proposes an alternate class revenue distribution that reduces the proposed revenue increase to the residential service class by approximately $5 million.
Excuse me, sir. I'm sorry to interrupt you again, but we're having problems hearing you. Is it possible for you to call us and you talk on your phone?
Yes.
Do you have a handset? Do you have a phone?
Not on this particular device.
I don't think he's on a phone.
I'm on a speaker phone only. Any better now?
That is better.
Okay. So I'll try to finish. I'm almost done anyway, so we'll work on that for tomorrow. Sorry about that. Dr. Dismukes finds that the company's class cost of service study is based on a coincident peak measure of demand, but that is inconsistent with their operations in their general fleet. And he recommends that the commission adopt an average and peak cost allocation method, require the company to gather monthly system coincident peak information, and require the company to file an alternate cost of service study with a cost allocation based on the average of 12 monthly coincident peaks in its next base rate filing. The department has also co-sponsored witness Ted McGavran with the South Carolina Energy Users Committee. He will discuss transmission issues, but I will leave his introduction to Mr. Elliott. Just in closing, the department recognizes the complexity, breadth, and depth of issues that will be covered in the course of this hearing, and we appreciate the Commission's expertise and attention to all of the testimony that will be presented, and look forward to addressing any questions or concerns you may have. Thank you.
Thank you, sir. Frank Knapp, Jr.
Let me get rid of something here. Thank you, Chairman Williams and Commissioners. I am Frank Knapp, representing myself in this hearing. I have been a party.
Hey, Mr. Knapp, could you talk into your handset?
I can. Is this better, sir?
Yes.
Okay, very good. Thank you, and I apologize. As I stated, Chairman Williams and Commissioners, I am Frank Knapp, representing myself in this.
Mr. Knapp, I hate to interrupt you. Give us 1 second. We're having some technical difficulties. All right, Mr. Knapp, sorry about that. If there's any option to increase the volume on your telephone, please use that option. Please proceed.
How about now, sir?
Perfect. If you could stay there, it would be great for us.
Well, if I could have that attribute perfect all the time, that'd be great. Chairman Williams and Commissioners, I am Frank Knapp, representing myself in this hearing. I've been a party to such hearings for going on 19 years. I would have preferred to have addressed the Commission in person to say hello to you, Mr. Chairman, and to Commissioner Irvin, and to welcome the new members. I will miss speaking with the other interveners in person. Unfortunately, we are in a health crisis that requires a new but less friendly approach. But we do have some new things that I am looking forward to. We have a newly missioned Office of Regulatory Staff for a regular electric rate hearing, an ORS that is no longer concerned about the utility, and consequently, ratepayers will have the full benefit of ORS's superb expertise. We have a new role for a consumer advocate, aggressively pursuing the consumer's best interests. And we have new opportunities for this commission. There is the new opportunity for this commission to minimize the cost to consumers for the previous commission's incorrect decision to require ratepayers to pay $2.3 billion for a nuclear project that will never be used and useful. There is the new opportunity to correct a problem that has been around for well over a decade. Small businesses like mine unfairly subsidizing some of the other customer classes with rates that are far outside the standard band of reasonableness for overall retail rate of return. So I look forward to all the newness in this hearing. Thank you for allowing me to play a small role.
Thank you, Mr. Knapp. Walmart Incorporated.
Good morning, Chairman and Commissioners. Again, my name is Stephanie Eaton, and I'm a member of the law firm of Stillman, Thomas & Battle in Winston-Salem, North Carolina. I represent Walmart in this docket, and we are happy to be able to participate in this hearing before most of you who are new commissioners. And like Mr. Knapp, we wish we could do this in person, but we appreciate the commissioners having this hearing virtually so that we can get to this important business. In South Carolina, Walmart employs over 32,000 associates in its 123 retail units and 4 distribution centers, 34 of which are in Dominion's territory. Walmart's facilities are served on a time-of-use large general service rate, a medium general service rate, and also a general service time-of-use demand rate. Electricity is a significant operating cost for retailers like Walmart, and when rates increases, operational expenses also increase. Therefore, in light of Dominion's application for a rate increase, Walmart filed a petition to intervene on September 22nd, 2020, and has submitted the pre-filed direct testimony of its Senior Manager of Energy Services, Ms. Lisa Perry. As explained by Ms. Perry in her pre-filed direct testimony, Walmart's chief concerns in this docket are the company's requested revenue requirement of $178 million and an ROE of 10.25% when viewed in light of the following facts. First is the impact of the resulting revenue requirement increase on Dominion's customers. Second is Dominion's proposed operating return increase of 37.7%, especially when considering Dominion's use of mechanisms outside of base rates for revenue collection, such as its DSM and fuel cost adjustment rates. Thirdly, ROEs approved in South Carolina and elsewhere have a median authorized ROE of 9.6% between the years of 2017 and 2020, and that does not support the company's proposed continuation of an ROE set in 2012 of 10.25%. Further, there is a lack of support for a financial risk adjustment or a flotation adjustment to offset the claimed risk investment in Dominion. Further, you also have to consider the fact of that Dominion, as presented today, is not the same company that asked for a rate increase in 2012. And finally, as I believe Dominion even mentioned in its opening, is the current U.S. and South Carolina economic climate. And with all of those factors, Walmart asked the Commission to reconsider the request by Dominion for an ROE of 10.25% and issue something closer to the median authorized ROE. Moreover, while Walmart does not take a position on Dominion's proposed cost of service model at this time, Walmart does oppose Dominion's proposal to recover the storm damage component, if allowed, from demand-metered customers through an energy charge. For demand-metered customers, Walmart respectfully requests that the Commission requires Dominion to recover storm damage component versus demand charges or dollar per kilowatt charges. Again, Walmart appreciates the opportunity to present testimony and evidence for the Commission and to participate in these proceedings. Thank you all for your time and attention.
Thank you, ma'am. AARP.
Good morning, Your Honor. This is John Kaufman on behalf of AARP, and on behalf of the association, we would like to sincerely thank the commissioners for scheduling ample opportunities for public comment. I know it's very difficult during the pandemic to get people to come or to find a way to virtually make their comments, but I think that the record that has been built up from those comments was very revealing and very powerful to what I listened to, and we would encourage the commissioners to review that and consider those comments in the context of this case. and consider where many people are financially, and that this electric service that Dominion does provide in a safe and adequate way is an essential service. And so for many people, this is something that they are, it is very difficult for them to have to pay for every month. And so we ask that the Commission approve no increase that is not justified, and that you take a hard look at this return on equity, which is being requested at a rate much higher than we're seeing around the country. And so that on that issue, we defer to ORS and other parties, consumer parties that weigh in on that. We are offering, in this case, a testimony from Scott Rubin, which is a noted expert on rate design, which is how the increase, if there is any increase coming out of this case, should be applied. We are primarily focused on having no more increase in the fixed charge, the base facilities charge. It is at $9 now, and Dominion is asking that be increased by 27%. And not only is this an unpopular way to charge residential customers, it takes away the control the customers have over their bills, discouraging conservation. We prefer, if there is any increase, that it be applied to the usage or volumetric component of rates. There are some other rates that we think really haven't proven out. I won't go into those, but we have some other rates, residential demand rates and so forth, that we believe should be discontinued. And with that, I will end, and thank you for letting us participate.
Thank you, sir. South Carolina Energy Users Committee.
Mr. Chairman, this is Scott Elliott. I appreciate the opportunity to make a brief opening argument. I would like to bring to the attention of the Commission and invite their attention to the issues raised by SCIAC witnesses McGavran and O'Donnell. First, with respect to certain transmission assets, Dominion is seeking recovery of approximately $322 million in transmission assets, which were constructed and financed pursuant to the Base Load Review Act. In 2009, this Commission granted then SCE&G the authority to construct 2 nuclear plants and the attendant transmission assets necessary to convey the 2,200 megawatts of electricity throughout Dominion's system. The plants were abandoned, as I think is well known to all, in July of 2017. However, the company chose not to abandon the construction and recovery of the transmission costs. The first is a legal matter. Having filed to recover the transmission costs under the Base Load Review Act, Dominion is now stopped from recovering these costs at all. The Base Load Review Act and the statute under which the company is requesting recovery today are different statutes. The BLRA provided the Dominion with the benefit of an upfront prudency decision. It allowed Dominion to recover its financing costs, its AFUDC, as it constructed the plants, which permitted them to recover from ratepayers in rates these costs, even though the transmission lines were not used and useful. Under sections 58-27-820, 860, and 870, the proof is different. The company would have been required, had they sought recovery of these transmission assets initially through these statutes, to wait until the transmission lines were constructed, run the risk of overruns or run the risk of being found imprudent, and then hope to recover their costs. It sets up a classic election of remedies issue here in this case. The company has, by virtue of the fact that the General Assembly repealed the Base Load Review Act, and by virtue of the fact that the company initially elected the remedy of recovering these costs under the BLRA, they are now stopped from recovering these costs altogether. In the alternative, what the evidence of record reveals is that these transmission lines, which were designed and constructed to transmit 2,200 megawatts of electricity generated by 2 nuclear plants, are no longer serving that purpose. These plants have been abandoned, and yet the lines were constructed with a considerable capacity over and above what is necessary today for the used and useful ability of the utility to recover. The evidence, the ORS evidence, for instance, shows that the transmission lines are not even at 20% capacity. Frankly, the company is trying to bootstrap its recovery of these underutilized, undercapacity lines in this proceeding, and they have failed to prove the value to the ratepayers in this case, and should be denied recovery of these costs. I would point out that the company is seeking recovery of about $68 million in grid investment improvements, to which we object. In particular, these items are found in Mr. O'Donnell's testimony at Table 2, but they're looking for AMI, advanced analytics, cybersecurity, and so forth. Mr. O'Donnell acknowledges that the cybersecurity costs are reasonable and would be used and useful, but Mr. O'Donnell recommends that the Commission disallow $50 million in these costs. Moving to the cost of service study, there is a dispute in this case over the use of the coincident peak allocator in designing rates. The Dominion, the ORS, and SCIA subscribe to the use of this CP allocator, as it's called. The company's used it for 38 years. All 3 of the large investor-owned utilities use it, and we advocate for the continued use of it. There's a witness in this case, Professor Dismukes, who suggests an alternative allocator. However, when Mr. Dismukes' own evidence points out that ultimately use of this alternative allocator would give rise to a 22% rate increase for South Carolina and Dominion's industrial customers. And so we would argue that that's neither in the public interest or just and reasonable, and you will hear testimony from Mr. O'Donnell about the coincident peak allocator. Mr. O'Donnell also recommends to the Commission that the company's requested cost of debt be rejected by this Commission. The difference in revenue to the company is approximately $24 million. The company has sold some debt, refinanced rather some debt, and has incurred penalties, and it raises their cost of debt substantially, and we submit that the shareholder should pay for that $24 million in costs. Last, Mr. O'Donnell will testify and recommend that the ROE associated with the Capital Cost Recovery Rider, or CCR, be reduced from the 9.9% as authorized in the 2018 order to whatever the ROE found to be reasonable by this Commission in this case. For instance, if the Commission were to find that an 8.9% ROE would be reasonable, that would save the ratepayers $13 million, almost $14 million. It's important to remember that this Capital Cost Recovery Rider, the CCR, is basically about $2.5 billion in abandoned nuclear costs. And frankly, it makes no sense for the ratepayers to have to pay a premium to the utility to recover those any financing costs on those assets that are not used and useful. Frankly, there's no risk associated with the capital cost recovery rider, and therefore the ROE should be no higher than the ROE on any other asset, and arguably lower. I would appreciate your patience with me and with all of us in this proceeding. It promises to be long, and we will hope to make it as succinct to you as we can. But thank you very much, Mr. Chairman.
Thank you, sir. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy.
Thank you, Mr. Chairman. This is Kate Mixon representing states and CCL, and we appreciate the opportunity to be here today. Electricity is a basic necessity and an important aspect of a utility's mandate to provide reliable service at reasonable rates is that service be affordable. Many of Dominion's customers face significant hardship paying their utility bills before the pandemic, and certainly even more so now. Yet Dominion's proposal contains little to explain these practical impacts that its rate increase will have on its customers, particularly low-income customers for whom a rate increase could prove particularly disastrous. We are also concerned about Dominion's choice to recover more of its costs through an increase to the basic facilities charge. Fixed charges hit low-usage customers the hardest, and data consistently shows that lower income and fixed income customers tend to use less electricity. Increasing fixed charges also reduces customers' ability and incentive to lower their electric bills by investing in energy efficiency or rooftop solar, tools that can reduce costs not only for individual customers, but also for the overall electric system to help lower costs for everyone. In sum, we are concerned that Dominion's proposal could further exacerbate affordability issues both in the short and long term, and ask that the Commission keep affordability in mind over the course of these proceedings and reject the proposed increase to the residential basic facilities charge. Thank you.
Thank you, ma'am. Office of Regulatory Staff.
Thank you. Good morning, Mr. Chairman, Madam Vice Chairman, and members of the Commission. This proceeding will likely last at least the 2 weeks that the Commission has scheduled. The parties in this proceeding have pre-filed the testimony of 37 witnesses. The Commission will hear nuanced arguments about many complicated matters. However, in the end, the Commission's decision largely will come down to something very simple: the determination of what is just and reasonable. The Commission will have to determine whether it's reasonable to award Dominion the ability to earn a 10.25% profit, despite the fact that a 10.25% return on equity far exceeds the national averages and the most recent ROEs approved by this Commission. The Commission will have to decide whether it's reasonable to impose a $178 million increase in revenue when the evidence presented by the South Carolina Office of Regulatory Staff indicates that at most, Dominion may be entitled to only about $11 million more. The Commission will have to decide whether it's reasonable that this Commission ordered Dominion to place merger costs below the line in docket number 2017-370E only for Dominion to contravene Commission Order 2018-804A and seek to impose an increased cost of debt resulting from the merger on its customers in this proceeding. But perhaps most of all, the Commission will have to determine whether it's reasonable to grant Dominion's proposed increase in rates so that Dominion collects a total revenue of $2.3 billion. When you have heard from so many of Dominion's customers in South Carolina who are daily struggling to put food on the table in the midst of a global pandemic. The evidence that ORS will present to the Commission will clearly show that despite what Dominion is seeking, it is not reasonable to award Dominion the grossly exaggerated ROE of 10.25%, a $178 million revenue increase, and that Dominion must be held to the merger conditions that this Commission has ordered. It's incumbent upon this Commission to ensure that reasonableness rules and that Dominion's customers are protected. Thank you, Mr. Chairman. This concludes the ORS's opening statement.
Thank you, sir, and thank you to the parties for giving succinct opening statements. We're only 6 minutes over our schedule. As previously discussed, we're going to end early today so we can prepare for the public hearing scheduled to start this afternoon at 1 p.m. Tomorrow, we intend to start at 9 a.m. and go through 6 p.m. We will start with Dominion's first witness. Are there any questions?
Mr. Chairman, this is Scott Elliott. If we were to start at 9 o'clock, what time would Mr. Erskine have us check in?
8 o'clock.
Very fine. Thank you, sir.
Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy. We've got Mr. Blevins ready to go. If y'all want to go for maybe another 20 or 30 minutes, I think we can get his summary in.
No, we need to make sure we're polished up for our 1 p.m. public hearing. I appreciate you being prepared to proceed under normal circumstances. That's definitely the route we would take, but as everyone knows, we are not in, these are not normal circumstances. But thank you for the offer.
All right, thank you, Mr. Chairman.
If there's not anything else, we're going to close out for today. Well, we're going to conclude this portion of the hearing in preparation of the public night hearing, or the public day hearing. All right, thank you.